Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip in continuation of our series on the changes to the 2019 GAR, Georgia Association of Realtors contracts. Today I'm going to cover the changes that they made to the purchase and sale agreement and the counteroffer form. So please watch the other videos I have done on the in the series on the changes to the 2019 GAR purchase contract forms, and you can see what else has been changed. So on to the purchase and sale agreement. As I mentioned in the first overview video, GAR has changed all the form numbers. So the purchase and sale is no longer F20, it is now F201. It's now all the purchase and sale, all the documents having to do with the purchase and sale of a property are now in the 200s. So the purchase and sale agreement is now to F201. And again, in general, they just added some changes for clarification purposes and protection purposes. So the first thing they did has to do for clarification purposes where it mentions the closing attorney. So you know in paragraph A where you are, paragraph A6, where the buyer and the seller negotiate which party is to close the transaction. And of course, we all know the closing attorney represents the mortgage lender if there is a mortgage involved, and if not, the buyer gets to select, and that's all elsewhere in the contract. But regardless, the change that they made is some agents were putting in the name of a law firm, and some agents were putting in the name of an actual attorney who works at that firm. So just to clarify, what they did is they added verbiage so that if a person is named in that part, it actually means the firm. So here's how it reads, and this is in paragraph B6 of the purchase and sale agreement, and it says, buyer shall have the right to select the closing attorney to close this transaction, and hereby selects the closing attorney referenced herein. In all cases where an individual closing attorney is named in this agreement, but the closing attorney is employed by or an owner, shareholder, or member in a law firm, the law firm shall be deemed to be the closing attorney. So that's the paragraph, that's the sentence that they added, is that if a person is named, it actually means the firm. Then it goes on, and this is no change, and it says, as I mentioned, if buyer's mortgage lender refuses to allow the closing attorney to close the transaction, seller shall select a different closing attorney acceptable to the mortgage lender. The closing attorney shall represent the mortgage lender in any transaction in which a buyer obtains mortgage financing, including transactions where the method of payment referenced herein is, quote, all cash. In transactions where the buyer does not obtain mortgage financing, the closing attorney shall represent the buyer. So again, they just clarified that if you name a person, it means the firm. They made that same, so here's another change. In the agency section, in paragraph B, in the agency section where it describes and just further defines what agency is, what client agency is, and it just defines the brokerage relationships. In the previous version, the first paragraph defined what a broker is. Every time the term broker is used in the purchase and sale, it defined what that means. They didn't change the definition, they just moved the definition. It used to be under the brokerage relationship section in paragraph B, and now they moved it to the definitions section in paragraph C. But the definition in and of itself did not change. So just in case, to remind you, let me read you what the definition of broker is as it is used in the purchase and sale agreements in GAR. It says, in this agreement, the term broker shall mean a licensed Georgia real estate broker, meaning the actual person who is the broker of the firm, or the brokerage firm and its affiliated licensees, unless the context would indicate otherwise. So again, no change in the definition. They just moved where that definition appears in the contract. The next thing they did is, we've already mentioned when we talked about the brokerage engagements, expanding the limits to the protection for you as an agent and the broker. And so they've added more protection in the purchase and sale agreement as well. And this states, it is in the, again, in the same section under the brokerage relationships in this transaction, under the agency disclosure in paragraph B10C, they have just added additional protection. And this is how it reads. Buyer and seller have not relied upon any advice or representations of brokers other than what is included in this agreement. Brokers, and we just defined what a broker is, it means you also, as the affiliated licensee, have no duty to inspect the property or advise the buyer and seller on any matter relating to the property which could have been revealed through a survey, appraisal, title search, official Georgia wood infestation report, utility bill review, septic system inspection, well water test, tests for radon, asbestos, mold, methamphetamine, and lead-based paint, moisture test of stucco or synthetic stucco, inspection of a property by a professional, construction expert, structural engineer, or environmental engineer, review of this agreement and transaction by an attorney, financial planner, mortgage consultant, or tax consultant, and consulting appropriate governmental officials to determine, among other things, and without limitation, the zoning of the property, whether any condemnation action is pending or has been filed, or any other nearby governmental improvements are planned. Buyer and seller acknowledge that the broker does not perform or have expertise in any of the above tests, inspections, and reviews, or in any of the matters handled by professionals referenced above. Buyer and seller should seek independent expert advice regarding any matter of concern to them relative to the property and this agreement. Buyer and seller acknowledge that brokers shall not be responsible to monitor, supervise, or inspect any construction or repairs to the property, and such tasks clearly fall outside the scope of real estate brokerage services. Then it goes on to say, so that's the added protections they added and how they reworded it a little bit. That same sentence goes on to talk about if you, as an agent, write a special stipulation. Y'all see me cringing. Anyway, please, if you're going to write a special stipulation, please don't. If you are going to, please consult the library of special stipulations already written for you in the GAR special stipulation library. Many times you as agents try to write a special stipulation, but it doesn't have proper timeframes or consequences or forms of notification. And what you do is you write a special stipulation that supersedes an issue that was already addressed in the purchase and sale, and you have totally taken away protection for your client that you meant to add. So please don't. If you do, please check the special stips already written for you in GAR. If there's something there for whatever reason does not address your concern, please check with your broker or an attorney. But the law here in Georgia has allowed for us as agents to write special stipulations. So let me read to you what the disclosure about that is to the buyer and the seller, and it is contained in the same paragraph. And it states, if broker has written any special stipulations herein, the party for whom such special stipulations were written, A, confirms that each special stipulation reflects the party's complete understanding as to the substance and form of the special stipulation. B, hereby adopts each special stipulation as the original work of the party. And C, hereby agrees to indemnify and hold the broker who prepared the stipulation harmless from any and all claims, causes of action, suits, and damages arising out of or relating to such special stipulation. So that is the paragraph under the agency disclosures. Another thing that they added, that GAR added for 2019, I think you guys are going to like this one. This has to do with the condition of the property at closing and time of possession. So it is couched under paragraph C3, where it talks about risk of damage to the property. And what it stated is they added a sentence about personal property, that the seller must take all personal property with them that was not negotiated in the contract to stay, so that a seller doesn't leave an item of furniture that they couldn't sell on a yard sale or couldn't move or anything along those lines. For that was just an example. It just addresses personal property. So let me read to you that whole paragraph, and when I get to the part about personal property, that's the change to 2019. It states, again, paragraph C3, under risk of damage to property, seller warrants that at time of closing of the property and all items remaining with the property, if any, will be in substantially the same condition, including conditions disclosed in the seller's property disclosure statement, as on the binding agreement date, except for the changes made to the condition of the property pursuant to the written agreement of the buyer and the seller. At time of possession, seller shall deliver property clean and free of trash, debris, that had already been there, here's what they added, and clean and free of trash, debris, and personal property of the seller not identified as remaining with the property. Notwithstanding the above, if the property is destroyed or substantially damaged prior to closing, seller shall promptly give notice to the buyer of the same and provide buyer with whatever information seller has regarding the availability of insurance and the disposition of insurance claim, so forth and so on. Then it goes on about termination rights if the property is substantially destroyed. But the change they made is clean and free of debris, that had been there, clean and free of trash and debris, had already been there. They added the part about personal property. Another provision that they added in this section under other, paragraph C, this again is still in relation to the Consumer Financial Protection Bureau and the TRID laws that first went into effect in October of 2015. TRID stands for the Truth in Lending RESPA Integrated Disclosures. And part of that law was that had to do with closing attorneys and lenders basically sharing or not sharing information with anyone other than the buyer. So the laws have been altered just a little bit, and GAR has addressed that in the 2019 contract, again reworded from how it used to be a couple years ago. And what it states, it is a new paragraph, paragraph C4B, and it's under consent to share non-public information. Buyer and seller hereby consent to the closing attorney preparing and distributing an American Land Title Association, ALTA, estimated settlement statement combined, or other combined settlement statement. Not all attorneys use that particular form for their closing statement. So they added in the addition. It had been mentioned previously about that form. They added in addition other closing statements that closing attorneys use. So the ALTA or other combined settlement statement. Let me back up. Buyer and seller hereby consent to the closing attorney preparing the closing statement, basically, that they can share that statement with the buyer, seller, brokers, and brokers affiliated licensees working on the transaction reflected in this agreement for their various uses. The other thing they added in the section under no authority to bind, this is paragraph C4I. That paragraph had already been in there. It just further clarified what the parties are to do if there is a dispute over the binding agreement date. So the paragraph that had already been there states, no broker or affiliated licensee of broker by virtue of this status shall have any authority to bind any other party hereto to any contract, provisions herein, amendments hereto, or termination thereof. However, if authorized in this agreement, brokers shall have the right to accept notice on behalf of the party. That had already been in here. Here's the addition. Additionally, any broker or real estate licensee involved in this transaction may perform the ministerial act of filling in the binding agreement date. In the event of a dispute over the binding agreement date, it may only be resolved by written agreement of the buyer and the seller. Don't let that confuse you, because you can determine when the binding agreement date is. So this should not be an argument. If there is a discrepancy or confusion over it, you can clearly determine when the binding agreement date is in a purchase and sale agreement by looking at the definition of the binding agreement date, which is notice of acceptance, and under the terms of the notice if it's sent electronically. So it can be determined by looking at that. I'm not going to go into that into this video, but there really shouldn't be any discrepancies over when it is. They made a couple of other changes that just are words. Again, as with everything, they alphabetized the exhibits for ease of finding, and other changes I've already mentioned. So that's really it for the purchase and sale. Not a whole lot of changes. Regarding the change, they only made one change to the counteroffer form, and I really love this change. The counteroffer form, as you know, is it clearly states in there that all parties agree that the terms of this agreement, the binding terms upon the parties, are everything from the original offer and whatever has been modified in the counteroffer. And you know you're only going to go binding with one counteroffer form. There's only going to be one counteroffer that has both buyer and seller signatures. So if you're going back and forth in counteroffers, the intermediate counteroffers do not count. So if you have something that is agreed upon in the first counteroffer form that is a modification from the original, but the other terms aren't agreed upon, you need to carry through those agreed upon terms in each successive counter. But the final counteroffer, the terms that go binding upon the parties, you're only going to have two documents: the original purchase and sale offer only signed by the buyer, and one counteroffer form signed by the buyer and the seller. And again, all the exhibits and special stipulations are already referenced in the counteroffer form, so you don't need to go back and re-initial those. But what the change is that they made is in the counteroffer form in and of itself, GAR has fill in the blanks. It has changes, and to help you guys, it has a fill in the blank for the sale price, for the closing costs, so forth and so on. Well, some agents were putting in NA if there wasn't a change from the original offer, but NA stands for not applicable. So for example, if you're only countering the closing costs, but you're agreeing, the buyer and seller agree on the purchase price, some agents were putting in NA on the purchase price fill in the blank on the counteroffer form, which really didn't make sense. So what GAR added is a provision for NC on the counteroffer. That means no change. So thank you, GAR. We love that. So the way it reads, and these instructions are written on the counteroffer form, and the way it reads, it's under paragraph E, terms and conditions. It says the following terms and conditions of the original offer are modified as follows. Parentheses, the sections not filled in or marked NC for no change, which shall mean that no change is being proposed to that section of this agreement, shall not be part of the counteroffer and shall remain the same as set forth in the original offer. So those are the changes to the purchase and sale agreement and the counteroffer form. Please watch the other videos on all the changes and stay tuned for more videos on more changes to the 2019 GAR, Georgia Association of Realtors contract forms. We are hosting a myriad of classes for 3 hours continuing education credit. No cost to these classes in all of the hosted by Maximum One Realtor company, branches throughout all of Metro Atlanta. I will link the online training calendar. We welcome all agents from all brokerages, and so hope to see you in a class. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.